Okay, let's jump right into this. Imagine you're just sitting at your desk, going about your day, and you stumble across something that is just off. Maybe it's a spreadsheet that clearly shows double billing to Medicare, or an email thread talking about bribing doctors to use a specific medical device. Suddenly, you realize you're holding a smoking gun of corporate fraud against the federal government. So, what do you do next? Exposing massive corporate fraud is definitely not the same thing as filing a complaint with HR. It's a high-stakes, highly covert tactical operation. In today's Explainer, we're diving into the Insider Survival Guide to Whistleblowing. We'll break down the exact playbook you need to successfully expose fraud under the False Claims Act. And honestly, more importantly, how to avoid the fatal amateur mistakes that can ruin a federal investigation and your own life in an absolute flash. $70 billion. Let that sink in for a second. That is the amount of money recovered for taxpayers since 1986 under the False Claims Act. We're obviously not talking about pocket change here. When rogue companies rip off federal programs like Medicare, Medicaid, or the Department of Defense, the government uses this specific law to claw that money back. And here's the thing. The government relies heavily on insiders, people just like you, to bring these shady, under-the-radar practices into the light. But this brings us to a massive dilemma. How do you actually report this fraud and claim your legal share of the recovery without accidentally blowing the entire case? Because the reality is, the potential financial reward for a successful whistleblower is absolutely massive, but the risk of making an amateur mistake, it's severe. Literally one wrong move, one misplaced email, or one casual conversation with the wrong coworker, and poof, the whole case evaporates. So, to navigate this safely, we're going to follow a strict 5-step tactical survival guide today. 1. The ticking clock. 2. Gathering your arsenal. 3. Strict legal standards. 4. The danger zone. And finally, 5. The payout. All right, step 1. The ticking clock. And trust me, it really is a race to report. The False Claims Act has this incredibly cutthroat, unforgiving provision that's known as the first-to-file rule. Basically, only the very first person to file a lawsuit reporting a specific fraud is eligible to recover a monetary award, period. So imagine whistleblower A beats you to the federal courthouse by a single day. Actually, scratch that, even by a single hour. If that happens, you're whistleblower B, you are completely barred from getting a single cent, even if the information you brought was vastly superior. The takeaway here is absolutely crucial. You cannot just sit on this information forever. You've got to move quickly and decisively to lock in your spot. Moving on to step 2, gathering your arsenal. This is all about the evidence phase. Listen, federal prosecutors and agents do not care about water cooler gossip or rumors. To meet the incredibly strict legal pleading standards of a federal court, you have to bring hard, highly organized proof. We're talking internal emails where executives are explicitly discussing fraudulent practices. We're talking training materials instructing sales reps to actively break the rules, or company presentations and internal memos that map out an organized scheme. When you carefully compile this kind of concrete internal evidence, you transform a vague, unproven allegation into a full-blown, actionable federal investigation. But here's the catch. Digital data is super fragile, which brings us to 3 vital steps you have to take. Step 1. Identify exactly where this key electronic data lives. Step 2. Ensure the immediate preservation of this historical data. Federal agents will tell you these frauds can stretch back for years. And funny enough, evidence conveniently seems to vanish into thin air the second a company catches wind of an investigation. Step 3. Securely transfer this data to an experienced qui tam attorney. Do not, under any circumstances, blast this out on a public server or just forward it to your personal Gmail account without legal guidance. You have to meticulously preserve the integrity of the evidence. Let's look at step 3, strict legal standards. Welcome to the legal battlefield. One of the most common laws you might actually find yourself helping to enforce is called the Anti-Kickback Statute, or AKS for short. It strictly prohibits paying or receiving anything of value to induce referrals for federal healthcare programs. Now, you might be thinking of a shady briefcase full of cash, right? But anything of value is way broader than that. In recent cases, whistleblowers have exposed companies handing out luxury ski trips, VIP tickets to the Kentucky Derby, or even giving doctors shares in a clinic sold at way below market value, all just to steer business their way. It completely clouds medical judgment, and ultimately it defrauds the taxpayer. So how does this actually play out in the real world? When you and your lawyer file the complaint on day one, it is filed under seal. This is absolutely critical to understand. It means the case is kept on a top secret docket by the court. The public doesn't know about it, and the company you're accusing definitely doesn't know about it. By law, it sits under this strict seal for a minimum of 60 days, though the government often asks to extend that. During this window of absolute mandatory silence, the Department of Justice works behind the scenes, issuing subpoenas and doing interviews before finally deciding whether they're going to intervene and take over the case themselves. Which brings us to step 4, the danger zone. This is how you avoid making fatal errors. Generally, we see two types of whistleblowers, or relators. First, you have the helpful relator. This person stays completely quiet, secretly preserves the data, and just lets the federal agents do their jobs. Then you have the backseat driver. This is the amateur who gets antsy, starts warning targets, and decides to play detective by conducting their own rogue interviews. Whatever you do, do not be the backseat driver. Let's run through a rapid-fire list of absolute don'ts. Do not contact witnesses directly to poke around and see what they know. Do not give the target a friendly heads-up to see if they'll just settle things quietly. Do not proceed without experienced legal counsel, and absolutely, under no circumstances, breach the court seal by posting about it on social media or running to the press. Doing literally any of this tips off the company, gives them a chance to destroy evidence, and can easily get your entire case thrown out by a judge. I want you to listen to this direct quote from a federal agent with the U.S. Postal Service Office of Inspector General. They said, "Give us support without interfering." In other words, be a resource, not a backseat driver. They explicitly point out that when whistleblowers or their lawyers try to help by contacting witnesses or giving a heads up, it has a disastrously detrimental effect on the investigation. The FBI, the DOJ, the OIG, these are trained professionals. They need you to be a quiet, reliable asset, not a loud liability. Finally, we reach step 5, the payout. This is the final reward. And let me tell you, it can be incredibly lucrative. Because you took on massive personal and professional risk to bring this fraud out of the shadows, the False Claims Act actually mandates that you get a significant piece of the pie. A successful whistleblower is legally entitled to between 15 and 30% of the massive government recovery. So in cases where the government recovers tens or even hundreds of millions of dollars, your quiet, strategic decision to step up can result in a truly life-changing reward. So we come all the way back to you, sitting right there at your desk. You hold the evidence, and now you hold the playbook. You know you've got to act fast to beat the clock. You know how to securely gather that hard documentation. You understand the need for absolute secrecy, and you know to step back and let the professionals handle the heavy lifting. The only question left is, are you ready to make the right move? Because honestly, the taxpayers, the legal system, and your own future are all waiting to see what you decide to do next.